भैया बाय कर लो, भैया बाय कर लो।
I would request all the attendees to please close their cameras.
पर्सन 22 पार्टिसिपेंट्स हैं। Good evening, everyone. The participants will be here with us shortly. I request you to be patient until then, and the debate is going to begin in a very short while. Thank you. Good evening, everyone. I am Ayushi Tiwari. While the participants are joining back in the main meeting, I welcome you all on behalf of the Debate and Discussion Committee at Ram Manohar Lohia National Law University to the first edition of the Alternative Debate and to the Competition Law Round. We seek to combine parliamentary debating and legal discourse by our new flagship event. The idea of alternative debate is to invite seasoned legal professionals prolific in a particular field of law to debate on contemporary issues, thereby providing the audience with rich insights stemming from their industry experience. The format which we shall be following divides the House into two sides: side government, which is for the motion, and side opposition, which is against the motion. Further, side government has two teams: opening government and closing government. And similarly, on side opposition, there will be opening opposition and closing opposition. At the end of the debate, we shall be releasing a poll for the audience to tell us if the substantive speeches they heard in the debate were able to change their views on the topic. So we request the audience to stay put until the end of the debate to register their opinion by the way of this poll, and the chat box will also be open for you to address questions to specific participants. I believe the participants are joining the meeting and the debate shall begin in a very short time. I request you all to go through the motion and the context to better grasp what the debate will be about. Thank you.
Hello, everyone. I'm Aisha. Before we begin, I take this opportunity to extend a warm welcome to the people who have made the maiden edition possible by their faith in us, our esteemed participants. In the opening government, we have the Prime Minister, Ms. Ravina Sethia, who is an associate with the competition law practice at Shardul Amarchand Mangaldas. She has completed her LLM from the University of Cambridge in 2018 and is a recipient of the Justice Pratibha M. Singh Scholarship and Wilson College Scholarship in association with the Cambridge Trust. She completed her BA LLB honors from Jindal Law School in 2017. Next, for the Deputy Prime Minister, we have Ms. Anjali Kumar, who is the competition law practice, who is an associate at the competition law practice at Shardul Amarchand Mangaldas. In the 3 years spent in this field, she has worked on a myriad of issues in competition and antitrust laws. Ms. Anjali has received her bachelor's in law from the National University of Juridical Sciences in Kolkata, and she is also selected for an exchange program for the Comillis University in Madrid, where she was on the dean's list in excelling particularly in competition law. In the opening opposition, we have the leader of opposition, Mr. Anand Shri, senior associate at Wesh Associates. Mr. Anand has graduated from Nuals Kochi in 2018. He is presently engaged as a senior associate with the competition law practice group at Wesh Associates. Anand sir has 6 years experience in competition law adversary and litigation, and also writes frequently on competition law issues and co-manages the blog Talking Competition. For Deputy Leader of Opposition, we have Mr. Ishan Chakrabarti, Associate at Sarvada Legal. Mr. Ishan Chakrabarti has assisted clients in competition and commercial law issues before the Supreme Court of India, high courts and tribunals, quasi-judicial bodies such as NCLAT, NCLT, CCI. He has graduated from Symbiosis Law School in 2019. For the closing government, in the member of government position, we have Ms. Ramya Hari, working as an associate at Cyril Charan Amarchand Mangaldas. Her practice includes advising on merger control issues, including filing pre-merger notifications with the CCI, advising on compliance and risk assessment, and enforcement matters. Ms. Ramya is an alumnus of Jindal Global Law School and is also seconded to a client of Cyril Amarchand Mangaldas as an interim chief compliance officer and has taught a part of the course of competition law at ILS Law College, Pune. For the position of government whip, we have with us Mr. Kirti Srinivas, Principal Associate at Cyril Amarchand Mangaldas. He regularly advises on merger control issues, including filing pre-merger notifications with the Competition Commission of India, and also advises various companies across manufacturing, healthcare, and various other industries throughout the course of his employment. In the closing opposition, lastly, we have the member of opposition, Mr. Vivek Pandey, Associate at Sarvada Legal. Mr. Vivek Pandey has worked on a range of matters, including competition law, insolvency law, civil, commercial, regulatory, and indirect taxation matters in Delhi. He has graduated from Symbiosis Law School and assists in matters before the Supreme Court, High Courts, and various tribunals across India. Lastly, we have our own alumnus, Mr. Danish Khan, who works as a principal associate at Dua Associates. Mr. Danish Khan has an extensive experience in competition litigation and advisory. He has advised and represented various clients before the Competition Commission of India and often regularly writes on Talking Competition, a blog. With that, I would be happy to introduce to the debate the opening government, the first Speaker of the House, the Prime Minister, and with that, we would like to commence the debate. Here.
Before we begin, just a short pointer to all the debaters. I have shared my screen in order for you to see the timer more conveniently. In case the other members of the panel have a question for the current speaker, they can write POI in the chat box. And if the speaker wishes to address it, they can say, I accept, and then you can unmute yourself and ask the question. Also, you can type the question in the chat box and the speaker can answer it after his or her speech has ended. For the same, I would also request the tech team to begin our poll, which will take the audience's opinion on the motion before they have heard the speeches of the House. And then we'll continue with taking the poll after the debate, which will tell us if the audience's opinion has changed because of the insights offered by our esteemed panelists. Members of the audience, as you can see, the poll is now live. I request you all to vote since we shall be closing the poll in 2 minutes from now. So I request you to make this vote count and register your opinion with us.
For the convenience of the audience, we would also be sharing our screens and displaying the context as well as the motion for the debate, so it becomes easier for you to answer the questions in the poll.
The audience can also access the motion on the Zoom group chat, as well as the WhatsApp groups that you have been made a part of. Both the motion and context are available on both the platforms. The poll shall be closing in 1 more minute, that is at 6:24. All of you who haven't voted, I request you to vote and register your opinions before the poll elapses. we just ended the poll and we've registered the final votes. Without further delay, I would now request the first Speaker of the House, the Prime Minister on site government, to come and present their case. Hear, hear.
Hi everyone, can you hear me before we start the time?
Sure, ma'am, you're perfectly audible.
Okay, I think I'm going to need a little more than 5 minutes just so that we have the context clear for this debate. So I would just request everyone to bear with me a little bit longer.
Sure, ma'am, whenever you're ready.
Okay. Cool, I think we can begin. Yeah. Good evening, everybody. I'm the first speaker on behalf of the proposition. I will begin my speech by first explaining what the motion is, our burden of proof, the context of today's debate, then move on to some key points that we want to make during the course of all our speeches and tackle some points of the opposition up front. Firstly, we define traditional tools of antitrust enforcement to mean tools, laws, measures, etc., that are most often used by regulators around the world to tackle these issues. Therefore, it excludes any such laws or regulations that exist on paper but aren't really being enforced. For example, Section 28 of the Competition Act, which allows the Competition Commission to break up a company, which has actually never been done. So that is not going to be a traditional tool according to the motion today. Secondly, our burden here is to merely tell you that the traditional tools are inadequate, but not to give you a foolproof solution for that today, although we will make fleeting recommendations here and there. Now let's look at the context, right? Big tech companies are really 4 to 5 companies that have access to big data. These companies include Google, Amazon, Facebook, and Apple, or Microsoft even to say. These companies are integrated across various levels of the supply chain and also in terms of cloud computing and data analytics. The biggest tools available to them here are that they have access to big data, they are highly integrated across various levels, and they use complex algorithms to be able to price or manipulate market positions. If you look at just Google as an example, it is not only a search engine, but it's present across Maps, YouTube, advertisement, Fitbit today, and several other platforms, right? Which just shows you how big these apps are. If we see from the perspective of end users like you and me, these apps are available on each of our home screens and our desktops, which shows the integration and the level to which our dependency on these companies is. Now, the key issues that we really have with the present or traditional tools in the antitrust regime in terms of merger control, firstly, are that several transactions really go under the scanner because of the high asset and turnover thresholds and the target exemption in India. According to those high thresholds, several acquisitions of small startups and small competitors by these big companies really go unnoticed. Therefore, our fleeting recommendation really is to maybe mandate any sort of acquisition by these big companies of smaller companies so that any enforcement agency is really able to understand the level to which these companies are integrated and trying to use their data and market power to further penetrate into various segments of the market. Secondly, when we look at remedies, there are 2 types of remedies largely, right? One is structural and the other is behavioral. In terms of structural remedies, we don't think that traditionally jurisdiction specific remedies will be an adequate answer. This is because these companies are firstly global in level. Data has been integrated on a global scale. And thirdly, we don't know and don't have the knowledge to understand which modus of their entire organization is where the divestment should really be ordered. Therefore, we don't think this, unless it is done on a global level, keeping in mind other regulators, will be a short solution. Secondly, we think behavioral remedies are very tough to be able to monitor. For example, when Facebook WhatsApp happened in the EU, they gave certain undertakings which were breached in 2017 by integrating WhatsApp, and they were fined 110 million euros in 2017, 3 years after the transaction. It was very hard for the regulator to even monitor what was happening. Secondly, we don't have the wherewithal to be able to understand what behavioral remedy will really be effective in this type of situation given the traditional tools. Flowing from that, our broader recommendations are that we really need a data expert and a permanent body of people in the enforcement division, at least in India. Without a data expert or a tech expert, we are very inadequately placed in terms of being able to deal with these companies and the threat that they really pose. Secondly, we think the tools of which we, in the way that we understand markets, really need to change. We can't look at markets unidimensionally as upstream and downstream, just because these companies are the platform and also the seller on the market. Now, if you look at Amazon, not only is it a seller, but it also provides the base through which its competitors are able to sell their own products. Amazon can then use the data that its competitors have for the product to be able to better its own product and sell it with an Amazon guarantee, which makes it much more viable for any buyer like you and me. right? The main goal here of these companies really to grab eyeballs, which is not really a quantifiable mechanism, which is why it's very, very important to rethink the traditional economic tools through which we understand market power and understand the presence, integration, and data of these companies on a broader scale. So don't just look at WhatsApp or WhatsApp payments, but look at Facebook and its data and how it's integrated to be able to increase market presence in all these mediums and streams. Thirdly, we think it's very important to have sector-specific guidelines to be able to really understand how the sector is being monitored and to be able to really tackle the way in which these companies really argue. Now, just to take 20 seconds more, the key points that we think the opposition is really going to make here are firstly that the merger regime in India is in fact changing. There are recommendations from the Competition Law Review Committee. To this, our response upfront is that these recommendations are merely in passing. Secondly, they still have a value threshold to them, and through them, these smaller acquisitions of small startups and companies may still pass through the radar. Thirdly, we think that by the time the legislation is passed, we don't know how long it will be, and that the regulator should really step up and come up with measures right now to be able to tackle the problems that really exist. Therefore, we recommend maybe fleetingly to enforce interim measures more frequently, which the regulator does not do as often. And secondly, in terms of agreements, maybe placing the burden of proof on these companies when they enter into any agreement to show how these agreements are in fact competitive. Secondly, we think that the other side will come and say that these companies are in fact driving innovation and competition in the market and leading to end consumer benefits by providing products at lower prices and much easier and cater to that specific consumer. To this, our response is that this is a very, very short-term approach, and it's very, very myopic in its understanding. Today, if you have a company like Amazon, which can use data from a seller, better the product and sell it in the market, you will not have so many sellers, A, being able to get funding because of Amazon's deep reach in this market, and secondly, being dissuaded to innovate. When this happens, you will be left in a situation like smartwatch market today, where you have only probably two competitors, Fitbit and Apple smartwatches, which are each backed by Google and Apple specifically. There is no other third watch in this market which is able to compete with them. And that is because of the deep penetration that these companies have and how much they have been able to stifle competition. Therefore, without having any sort of competitors, we don't think there will be innovation, better prices, or consumer good in the long run. With this, I rest my points. My speakers will come and they will take these points further. Thank you so much. It was great to argue today.
I thank the Prime Minister for that informative speech. I now open the floor for the opposition to pose any questions to Madam Prime Minister.
Am I audible?
Yes, sir, you're audible.
Hi. Is there a particular way we can put in questions to the Honorable Prime Minister, or is it that we can put in a question orally?
So you can put in the question orally or put it to the chat box, whichever way is convenient.
Whatever is convenient to Madam Prime Minister.
You can say it orally.
Oh, wonderful. Thank you so much for your proposition, Madam Prime Minister. Our basic premise to you and this question is that you have highlighted various arguments, which I imagine your co-team will elaborate further. Our basic question to you, Madam Prime Minister, is that in your entire speech, or maybe one of your co-team can elaborate this further. What are the theories of harm which you propose through? I'm imagining you are proposing a legislation to further enhance the powers given to the commission under the present statute. What are the theories of harm which you believe are applicable to the big tech industry, especially in cases of acquisitions of smaller entities by the big tech? What are the theories of harm which you propose which mandate an enhanced legislation? Right, because we're still looking for you. So we've heard that you need an enhanced legislation. My question to you is why? What are the theories of harm? Because from what I heard, you said that entities acquire smaller entities to make their products better or to have enhanced network effects. Is that all that the theory of harm which you suggest, or is there something more to it? If I could invite your attention to section 20, clause 4 of the present statute, and if I could request you to elaborate and enlighten us, what are the theories of harm which you propose through such acquisitions of smaller entities by big tech, which we need to dwell upon? Thank you so much.
Thank you for your question. First off, to clarify, our motion or context or the way we've defined the motion here today is not merely to suggest that there should be regulatory upheaval, but also to suggest that there exist certain tools which are maybe present in regulation but are not being used. So when we look at traditional tools, we are looking at tools that are most largely being enforced by regulators across. Secondly, it's very important to understand that when we look at these type of acquisitions that take place, where bigger companies acquire, these big tech companies rather acquire smaller companies or they acquire competing entities, the theories of harm are so immense. And in fact, it's very hard to be able to discern or point a finger to it right now because we're unable to fully understand the context to how large they really are. Therefore, I think upfront, if you ask me and you look at the acquisition of Instagram in 2012 by Facebook, a clear theory of harm there was that these people were acquiring something that they thought was a competitor, which we know now for a fact, given the current report that has been released by the House in the US, right, the Judicial Committee. We see that the theories of harm are in fact many-fold, and in fact they're trying to trying to just 1 second. I'm so sorry. I think I'm getting cut with the connection. Just give me a second. The theories of harm are not just that they have exclusionary power, right, to be able to sort of get rid of a competitor which may be big in the future, but it's also going to lead to certain harm in terms of the amount of data that they have, which is not contemplated in a traditional tool structure of antitrust, which is what we try to argue further in our points, I think. So I just think I'm getting cut. I think my connection is bad, but I hope I've answered your question in brief, and I can request my next speaker to sort of take it forward if that's okay.
Madam Prime Minister, if I could be requested one 10-second follow-up question. Not
Yeah,
more
let
than
me just cut this to see if it's better. Yeah.
Madam Speaker, am I allowed a 10-second follow-up question to this?
Yeah, sure, sir.
Okay, all right. Thank you for your response, Madam Prime Minister. My 10-second follow-up question is basically this. You are saying that the present framework has enough tools at the disposal of the Commission and the regulatory bodies to check any kind of anti-competitive behavior. That's what I heard.
No,
However,
no.
what you're also...
No, sorry, that's not what I'm saying. I'm sorry if there was a confusion. I'm saying that when we talk about traditional tools, we're limiting it to tools that are presently being used largely by regulators around the world. So not just a writing in a legislation which exists but is never being enforced. That would not count as a traditional tool.
If I could invite the attention, my apologies, if I could invite the attention back to the proposition which the House has floated, it says that the present framework, which I imagine is the statute, is not enough to cater to the challenges, which means, are you saying the framework is good enough? It's just not being practiced. Is that what you're saying? Thereby indirectly admitting that the framework is good enough, it's just not being practiced at the moment.
No, I'm not admitting or denying anything to do with the framework. All I'm trying to say is that the motion today deals with traditional antitrust tools. And in our definition, traditional antitrust tools are those which are being used most often by regulators. So therefore, it excludes provisions of laws which may exist in some jurisdictions or others, but are not being used as often to tackle. If anything, whatever's being used at least is insufficient. Let's put it that way.
Thank you, Madam Prime Minister, for your response.
I thank you for that speech, Madam Speaker. Before moving on, I would clarify for the POIs to all the participants. If you have a POI, you can write POI in the chat box during the course of the speech of the speaker, and they can choose to respond to it then or after they have concluded their speech. Also, we request the speakers to limit the POI to 15 to 20 seconds so that the audience can easily grasp the crux of the question and form their opinions, as well as the speakers who are coming after the current speaker can get enough time to put their views and rebuttals. With that being said, I would now request the next speaker, the leader of opposition, to come and present the case on side op. Here. I request the leader of opposition to begin their speech. If there are any technical difficulties, you can let us know and we'll help you resolve that. I got that, sir. I'll ask one of my team members to get in touch with you ASAP and we can resolve this. I request the audience as well as the participants to give us 2 more minutes to resolve the technical difficulty. The speaker is switching devices to join the platform. It'll take another minute or so. Please bear with us until then. In the meantime, I would like to remind the audience that as soon as the debate is over, we'll enable the chat box for asking questions to the panelists. And you're requested to specify the name of the panelist to whom you want to address the question so that it becomes easier for us and them to give a more structured response and in lesser amount of time. You can also share the YouTube link, which we've shared on the college's Student Activity Center to invite your friends to the debate. And I believe the speaker has re-entered the meeting and another 30 seconds and he'll start speaking, I believe.
Hi, hello. Hello.
Yes, sir, you're audible now.
Yeah, sorry for the technical glitch.
That's perfectly all right, sir. Whenever you're ready, I'll start the timer.
Yeah. Considering the technical glitch, I'm more inclined to support the motion rather than be against it. Okay. Thank you, Madam Speaker. Okay, we may start. Yeah. Thank you, Madam Speaker, for the invite and the opportunity to address this honorable House. Uh, it was a pleasure listening to the honorable Prime Minister. One particular statement made by the honorable Prime Minister struck me hard. Towards the end of the speech, she said that she is unable to understand fully the digital market. So I asked myself, why is the government rushing to regulate a market which the government does not fully understand? Secondly, the solution proposed by the government is that traditional tools are not sufficient. But however, rather than making the vague statement that the traditional tools are insufficient, they've not clarified as to how they will go about equipping the commission to deal with issues in the digital market, or what tools they propose to enable the commission to deal with issues in the digital market. Also, I am surprised that the motion passed by the government comes nearly a year after the report which has been uh, submitted by the Competition Law Review Committee. Uh, the government itself knows that the CLRC committee has in great detail deliberated and discussed all the issues relating to digital market and the apparent threat posed by big data companies. And what did they conclude? And it was concluded categorically that the competition law regime in India is flexible enough to tackle issues relating to digital economy. During the course of her speech, Madam Prime Minister has also relied on proceedings happening in the US. With due respect, Madam Prime Minister, the antitrust laws in the US are more than a century old. The Sherman Act was enacted in 1890 and the Clayton Act was enacted in 1914. So the legislatures in US are perfectly entitled and justified to seek a revamp of the antitrust laws. But the situation in India is not the same. Our competition law was enacted in 2002 and came to force fully in the year 2011. So as a modern competition law regime enacted in the 21st century, it is well equipped to deal with competition law concerns in the 21st century. In fact, the CCI itself, subsequent to the CLRC report, the CCI itself conducted an investigation into the e-commerce market in India. And the CCI also concurred with the CLRC report and was of the opinion that current legislative framework and tools are sufficient to meet the challenges in the digital market. Therefore, since both the CLRC as well as the CCI is of the opinion that the present legislative framework and the tools available are sufficient to address the issues in the digital market, I do not fathom the reason behind the present motion to bring in additional regulation or to with respect to the digital market. Madam Prime Minister had highlighted a key proposal in the form of addition of value thresholds for meeting the combination for notifying mergers to the CCI. My question to the Honorable Prime Minister is why are the digital companies uh, being singled out when this is a common practice that we see in the pharma sector as well as the biotech sector? It is these acquisitions known as killer acquisitions are common when a new drug is being developed by a company. It is common for big pharma companies to acquire the company and remove the competitive threat. So my question is, why are why are the big tech companies being singled out and uh, victimized by the government? Lastly, my point is, uh, so this admittedly this is a market that the government does not understand. Therefore, and legislators always have to play catch up, like which has been agreed upon by the Honorable Prime Minister. Therefore, when legislators are trying to catch up, what is the rush to regulate the market further, knowing fully well that legislation will never be able to keep up with the dynamism of the market? We are all aware of internet companies who have come and gone in the span of the last 10 years. Therefore, the way forward is not more regulation, but deregulation. And with this, I conclude the motion with an open challenge to the government to identify a single instance of behavioral conduct which cannot be covered under Section 3 Clause 1, Section 3 Clause 3, Section 3 Clause 4, or Section 4 of the Act. Thank you.
I thank the Leader of Opposition for that fine speech. I now open the floor to the government if they want to pose any questions to the Leader of Opposition.
Okay, hi, sorry, just give me a second. Yeah, so I think you said that regulators don't have the means and they always have to play catch up. I think, and you asked why we're limiting this to big tech companies and not pharma and other industries. I want to ask you, do you see no difference in the context between what big tech companies are doing, given that they're multi-sided platforms with data integration present throughout our lives in such a great big way, acquiring companies left, right, and center to increase their data and presence on a global scale, which is very different from what maybe bio companies are trying to do? And do you not think that these companies require a certain amount of antitrust investigation, at least at this stage? That also, I mean, almost 12 years after we first started looking at Google, to be able to sort of understand and control how they're able to stifle competition. I mean, this is the first time since 1970 that a Senate House has actually looked at companies with this much scrutiny. So don't you think that this looking at the scrutiny deserves any amount of attention?
I wish to clarify my statement. What I meant was acquisitions by big pharma companies cause as much competitive harm as acquisitions by big tech. It's just because we interact with big tech on a daily basis does not mean that we should disregard acquisitions by other companies. What I'm trying to say is that you cannot discriminate between these companies. Law should equally apply to everybody. Law, whether it's acquisition by a big pharma company or a big biotech company, if the acquisition is with an intent to remove a competitive threat, it should apply equally, regardless of which sector the company comes from. I hope that addresses the concern.
I mean, not really, but thank you. I don't think I can ask you follow-on questions.
All right.
Thank you, Mr. Speaker. With that, I would like to invite the Deputy Prime Minister to continue the case from side government. Hear, hear.
Hi, am I audible?
Yes, ma'am, you're perfectly audible.
Okay, thanks. I actually want to begin by, you can start my time. I want to begin by thanking the leader of the opposition for giving us arguments to support our motion today. Because essentially their case is that we are failing at catching these, the new threats to competition, and we should continue to fail. We should sit, wait with our hands on our laps and wait for another 100 years until our legislation is also outdated completely. And then say, okay, you know what, now it's been 100 years, we need to revamp our legislation. And the government today is just making the case that we need to act now, we need to act in a timely fashion, because the markets that we're dealing with today are very different from the markets that we dealt with when we framed the Competition Act back in 2002. These markets don't function in the manner that the markets functioned in even last even 2 years ago. These markets are affected by indirect network effects. They they're constantly changing, and the effect of one company being excluded is that the dominant enterprise, the Google, the Facebook, gets even more data. Its position is even more consolidated, and the sorry, I can see, and the barriers to entry of other competitors is even higher. I'm going to begin by rebutting the specific arguments that were made by the opposition, and then try and build a substantive case by saying that what we have today is a huge, pervasive, systemic failure of competition, of the Competition Act, and that our tools is insufficient, not because of the absence of any theory of harm that we can point to, but because there is no capability that we have as an investigative and a regulatory body to catch these anti-competitive practices. Beginning first with, if the legislation is not able to understand, then what are we regulating? The point is that the CCI has been created with the specific intention of understanding markets, of protecting consumers, of protecting innovation, and protecting competition in the market dynamically. We cannot say that we cannot understand these things dynamically. We have to put in an effort, because the effect is on the economy as a whole, on all consumers, on all competitors in the market. And to just throw our hands up and say we're not going to do it is frankly a very poor reason for not trying. Second, that the CCI and CLRC have felt that their provisions are already broad enough and able to deal with these new challenges that we have. I'd like to first point out the very selective way in which the opposition has referred to this, because in fact the CLRC itself said that, you know what, we are unable to catch killer acquisitions by the Google acquiring YouTube as soon as it becomes big enough to become a competing platform for data. It acquires it. Amazon acquires Deliveroo. Uber acquires Postmates, and we have no way of catching these. And that's exactly what we're saying. I mean, what we're saying is that what we lack today is any means of first checking and the future anti-competitive practices that might happen, which is by monitoring either M&A or unilateral conduct. Second, we have no way, I mean, this threshold for us to establish that there is anti-competitive harm is so high. We have to point to a specific theory of harm in the absence of the CCI having any sort of like technical expertise, having no permanent DG even, and then sitting there with no experts who have any understanding of this, no economists, and then grappling with these and against Google, who has its own team of people who try and keep users stuck to their phones all the time. And we need resources throughout the chain of events. We need resources to monitor. We need a tool to monitor. We need a tool to enforce. We need a tool to lower the threshold for anti-competitive harm, because it is too high a threshold to be met in the absence of any data on how this is playing out. I just want to close by reiterating that these activities that the big tech companies engage in is not limited to, is not open and apparent as they were in the brick and mortar times. I will take the POI. And after I'm done, and that these happen behind closed doors by way of hidden algorithms that we have no way of monitoring. And if we're going to wait another 10, 20, 100 years, then it's basically giving these big tech companies a free rein to go and monopolize every single market that they can.
I thank the Deputy Prime Minister for that speech. Ma'am, there is a POI in the chat box. Would you like to take that?
Yeah. Okay, so just to read it out, if the government can clarify what are the exact means that it proposes to address any anti-competitive harm which they believe are caused in the antitrust market. The House can only vote effectively it has clarity on the proposals made by the government. Sorry? Okay, sorry, I thought I heard someone. I think, okay, I'm going to take the first one first, which is what sort of anti-competitive harm, how we're proposing to address any anti-competitive harm. I think number one, I would like to reiterate that our burden today is not to find a foolproof solution. Our burden is to figure out whether the tools that we have currently are sufficient. And what we're trying to do is prove to you something that is very clear, in fact, because we have 5 big companies and everybody relies on these 5 big companies. And if that is not the absence of competition, I don't know what is. But the point here, even so, even like increasing our burden to finding the foolproof solution before we decide to take any measures, I'd say that number one, we need to have a way to monitor. How do we monitor if all the acquisitions that are happening are below the target exemption? How do we monitor if the conduct is so pervasive, so insidious that it happens by way of algorithms that we cannot detect? How do we measure if these companies are so large that we don't even understand what cross subsidization is taking place? How do we measure if these companies are engaging in the same conduct across all nations, and yet we decide, no, you know what, the US is a different, sorry, one second, US is a different regime, and we are in the 21st century having a modern enough law. And I think, I mean, that's one way. We need to have better monitoring mechanisms to be able to understand what's happening. I'm just going to take one more POI because there are several here. If that's okay. I don't know if I'm running out of time.
Ma'am, if you wish to, you can take one more POI. However, there's no need for you to take another POI because your mandatory POI is over. However, since there are 2 more POIs, you can take either one of them.
Okay. I just want to, I mean, I think they're mostly the same on the question of whether there should be a regulator for the digital economy or the CCI should also regulate the digital market concurrently. I think the answer is very simple. I don't think that the CCI is excluded from looking at any sort of market, be it digital, be it coal, be it oil, be it whatever, because it is part of another sectoral regulator's jurisdiction as well. And that's something that's absolutely clear, right? I mean, there's no question about it. The problem, and this actually supports our case, the problem is that the CCI does not have specific guidance on what it should do, when it should do it, and it is deferring to the views of other regulators to figure out what its own ambit is, and for that we need a legislative change.
Madam, once can you hear me?
Yes.
Hello. Yeah, I'm getting an echo. Sorry.
Sir, you're audible.
Madam, can you hear me now?
Yes, sir, you're audible.
Madam, am I allowed a 5-second follow-up question to the Deputy Prime Minister?
Sir, it would depend on the Deputy Prime Minister if she's willing to take the question.
I think I should really give the floor to the opposition to make their arguments and for my fellow members of the government to take the case forward. So I'd politely say no.
No problem, Deputy Prime Minister. My pleasure. Thank you.
Thank you.
With that, I invite the Deputy Leader of Opposition to continue the case from side opposition. Here.
Thank you. Am I audible?
Yes, sir, you're audible.
Okay. Thank you for all the speeches made before this, but I would like to just take a step back and initiate this discussion with, first of all, understanding what competition is. I have unfortunately heard a lot of imputations on big tech companies without actually making a substantive case against them. And for that, I need to clear what this debate is definitely not about. This debate is not about giving a positive finding about whether big tech is actually guilty or not. This debate is about whether our current statutory framework is adequate to find them guilty or not. With that, I would like to tell you that being big or being in the position of monopolist is actually one of the fundamental drivers in any kind of competition regime. We are not only talking about India, we are talking about just about any regime, but let's focus on India. Being big, being a monopolist is one of the fundamental drivers of competition and innovation. Let's keep that in mind, because I think unfortunately what has been said is that there are 5 big companies. That has been reiterated in the prime minister as well as the deputy prime minister's speech, that there are 5 big companies, and that should be a cause of concern, because that evidently shows that there's no competition in the market. That shows an unfortunate misunderstanding of what this market is all about. A service that is given by any of these big 5 tech companies requires prohibitively high amount of investment. I'm talking about huge investments that are needed to make the structure based on which we use our smartphones and take all these services for granted. Let's understand how these costs can be recovered. A company can only be efficient in any of these markets if it reduces its per unit fixed cost, which means to give as much service as possible. And this has led to a situation where big tech companies are essentially acting as natural monopolies. Now, if that is the submission from the government, that there are 5 big companies and therefore there is a problem and there is some kind of an insidious conduct, we need to understand this result is not because of some pernicious anti-competitive design, but only because the market behaves in such a way. The market concentration is a direct result of the nature of the services provided and not as a result of some anti-competitive conduct. With that out of the way, let me go to the next point, which is that our current law is more than sufficient to deal with any kind of eventualities that big tech might throw our way. The motion has unfortunately been defined in a very convenient way, which does not look at the existing statutes on book. If there is any kind of institutional failure without admitting that there is any kind of institutional failure, that is not a legislative failure. We need to understand laws are there on the books, and we need to know that the regulator needs to know that they are there and they need to be applied. A dynamic law is given to us, and it is our job to apply it. Now, let's look at the substantive changes that the CLRC report has failed to look at. CLRC report has, after evaluating our current legislation, has given a finding, and a lot of these findings have been taken in view of what is posed by big tech. First of all, the definition of price. We see Facebook, WhatsApp, Google search, everything is free. And there was a concern that our current law cannot deal with free services. Unfortunately, that's not true, because price, the definition of price under the Competition Act is dynamic enough to take into its view non-monetary consideration as well. Algorithmic collusion, coming to the next point, algorithmic collusion, even something that we've not witnessed happen before us has been contemplated within the ethos of the Act, because Section 3, subsection 1 is an omnibus provision which can cover this. Going further, there have been discussions on other agreements. We have talked about MFN, we have talked about hub and spoke. But if any kind of an amendment has been proposed because of these eventualities, we need to understand that's not a result of big tech. Hub and spoke existed before big tech, it will exist after big tech. Hub and spoke is just a business model. It has nothing to do with big tech. Coming to what big tech does pose is what has been elaborated by the Prime Minister and the Deputy Prime Minister, is access to vast swathes of data. Let's try to understand. This vast swathe of data has been taken into account when we look at the dominance of an enterprise, because Section 19, subsection 4, clause B says that the resource and the size of an enterprise is adequate enough to cover this, whether access to data poses a competition concern, whether it poses any kind of a barrier to entry. All these things can be evaluated within our current framework. So I don't frankly see a reason to enforce a new framework where there is absolutely no need for one. With that, I would just like a 10-second extension beyond my designated time. the rule change that has been proposed, it should not be blindly assumed that less concentration in the market would be better for consumers. I'd just like to pose a question to the audience. Would you like to have one Google search that works, let's just take it as an understatement, optimally well, or would you like to have 10 different search engines that takes hours for you to get the information that you can get in seconds right now? Because the rules that do not allow a firm to enjoy the fruits of its innovation would obviously chill innovation, and everyone will be worse off as a result. And finally, just one last point. I know I'm out of time, but I just need to make this one last point. There are a lot of concerns raised because of data privacy, because of this point has not been raised yet, but I'm sure it will be raised at some point during the course of the debate. There is a problem of fake news before elections, and because of which Facebook and other platforms are being increasingly scrutinized. Let's divorce these issues from competition, first of all. Unless there is an absolute effect on the market, we should not expect the competition regime to deal with just about every issue that comes our way. Do we actually blame tax policy for the increase in murder rates? We don't. We can look for a correlation if we are trained to look for one under a microscope, but that should not be confused for a causation between the two. Because it's unfair to blame the competition framework for these failures. Just as it is, because uh, we need to understand that, and I'll close with this kind of an unreasonable expectation from our competition regime is what has collectively imparted an interventionist bias upon this government. And with that, I close my speech.
I thank the Deputy Leader of Opposition for that fine speech. I now open the floor for any questions from side government. If there are no questions, then I would like to invite the
Sorry,
member of...
interject.
Yeah, sure.
Sorry, I just want to I want to ask the opposition, do users really have an option to switch to any other search? Because I mean, if the problem here is that the data has been concentrated only with Google, and any competitor that comes into the market that could viably compete with Google even in 5-10 years is being pushed out of the market using Google's position in other markets. And this, I don't think, I mean, I think it's been conveniently glossed over, but I want to draw this opposition's attention to the issue of self-preferencing. So if Google pushes Paytm, PhonePe out of its Play Store whenever it wants, how is Paytm and PhonePe or any other new competitor supposed to compete with Google Pay?
I'll take that question. Thank you for the question. First of all, I'd just like to point out that any kind of delays in how the decisions are given is not a legislative failure. We need to understand that. You talk about search bias. Google has been prosecuted in India as well as all over the world. I think EU has prosecuted, US, of course, we know the context of the debate Google is being prosecuted against, and search and self-preferencing is bound to be one of the issues. But let's look at the issue at hand is whether our current framework is adequate or not adequate. The fact that it has been prosecuted in so many jurisdictions, and coming back to India, it's been prosecuted by the Competition Commission. It's a separate thing that it's gone into appeal, and therefore it's a lengthy process, unfortunately, but that's an institutional failure, if at all, because these are lengthy investigations. By its very nature, competition investigations are lengthy, and it's important that we do not jump to conclusions before we give a finding that impacts essentially, as you have yourself said, the entire population. With that, and I believe I saw two questions there. One was whether users really have an effective choice. I believe they do. You talk about WhatsApp. If there is another competitor that comes that offers better services, it will displace WhatsApp, just as WhatsApp displays someone else. Innovation has a habit of displacing rent seekers from old economies. Let's look at, you're talking about options. So in case of search, we have Bing. So if you don't like Google search, you can actually go to Bing. No one has actually forced you to use Google search. But the very fact that so many people are using Google search, I believe is a testament to the innovation and the services that they provide.
Right. Am I allowed a point of information on behalf of the government?
Sure, sir. It depends on the speaker if they wish to take another point of information.
I'll take it, but are we not running out of time? I believe we are.
Maybe your co-speakers can take it up if you're running out of time. I would leave it to you, or I can probably put it on the chat box. I think that should also be fine.
Sure,
Yeah,
you
sure.
can put in the point of information. Yes.
Sounds good.
I thank the Deputy Leader of Opposition. I now invite the Member of Government from side government to continue the case for closing government.
Hi, am I audible?
Yes, ma'am, you're audible.
Yeah, you can tell me when you start and then I will.
Whenever you're ready, ma'am, I'll start the
Is
time.
it? Yeah, you can start it. Good evening, everybody. Thank you for the opposition speaker right before me for explaining our own motion to us. So how I'll structure this, my speech is first I will rebut 1 or 2, 3 points that were made by the speakers from opposition before me, and then I will put across my substantive points. The first point that I would like to rebut is what I saw through all the two opposition speakers was that they say that the CLRC and the CCI have said that the current framework is enough and that they don't need to legislate. But what is true here is that if that were the case, then the exclusion that we see right now wouldn't be happening, right? We know, or if you talk about e-commerce and you talk about Amazon or you talk about Swiggy and you say, that if there is competition or if there are other options, people will automatically use them. However, and they also mentioned the e-commerce study, but I was at the forum at the CCI about the e-commerce study, and I saw restaurants and other vendors organizations as well as other competitors of Amazon and Swiggy come across and tell them that they are getting excluded day in, day out. That is because the amount of data that Swiggy or WhatsApp or Facebook are today able to garner, or Amazon, they've had the first movers advantage. And we as CCI, or as if the legislation was sufficient, haven't been able to stop that. This is exactly as my first speaker said, what happened with Facebook and WhatsApp. Facebook and WhatsApp, when in 2014 was notified to the EC, they saw no problems with it because Facebook took an undertaking that we are not going to share data. 2 years later, they changed WhatsApp's privacy policy, and lo, they are the biggest. WhatsApp today has 45 to 50% market share in the Indian market as well. Then and it is also not true that the CLRC has given no recommendation to the present legislation that is in place. They have already told us that we should include deal size thresholds when assessing mergers, because Facebook and WhatsApp wasn't even notified in India. Because, and everybody knows, when big tech companies or even tech companies are make a foray into the market, or when an acquisition happens, they are not asset heavy. When you talk about investment and you talk about Facebook, WhatsApp having so much investment, that is not true. Because if that was true, then the Facebook, WhatsApp acquisition would have been notified in India. It wasn't, because their turnover wasn't high and the asset wasn't high. And we didn't have a database metric assessment. Then moving on to the third point, that if you think that the natural way a market should go is a monopoly, then I would assume that as the government, we would want to legislate to not let that happen. Just because it's a natural progression of how competition works, that hasn't stopped us from legislating before and shouldn't stop us now. And on the point of how the pharma industry also has mergers, why are we singling out big data? It's because the challenges that big data poses and is widely known and is accepted are very novel. These are multi-sided markets. Then I move to my substantive points. The first substantive point I've already made is about the Facebook, the deal size threshold or the database threshold. This could have actually been taken up by the CCI in the most recent Facebook Geo acquisition that happened. In fact, they went to the extent of saying that they agree that they function in complementary markets. There is going to be sharing of data. The sharing of data will probably give them market dominance, but they said we will wait and see how this plays out and then take this on later. They did not even take an undertaking. So if in the merger control regime they already had the tools to do it, and there is going to be dominance, I don't see why you would not want to avoid that. Also, to set the motion again, I think we are missing the point of the entire motion here. If the legislation was adequate, then the regulator would have taken this up over the multiple cases that have happened in the 8 years since big tech companies emerged. For example, it took the commission 8 years to even delineate relevant market for offline channels and online channels. And if they were clear, or if the legislation was clear as to how to deal with database markets, or where the very point of those transactions is data, then they would have divided, or they would have delineated this relevant market much more appropriately. And then we come to the point of how you can just switch from one platform to other, multi-homing, etc. That is a great point. However, once you've driven out all the competition, that point doesn't stand. For example, Amazon, it's driven out so many of its competitors because it can leverage the data in one market to another market. It's identified the gap that exists in demand and supply and fills it with its own brands. And how is that not a problem, or how that case was brought to the CCI and the CCI said, oh no, this is actually not an issue. So we will not, the legislation doesn't provide for it, or it's a data privacy issue, so we can't go into it. That clearly means that the legislation is failing. It's not adequate. Or even by far, if you argue that even if it is adequate, then somebody please provide more guidance through legislation to the CCI so they understand what they are required to do in these markets. And for the last point, if I may have another 30 seconds, is the point on consumer benefit. You say everybody wins. Yes, for now. But tomorrow, once you've driven out all the competition in the market and you're the only person or only player left, let's see how low you'll price, how low Amazon will price its products. So with that, that's my ending statement.
I'd like to thank the member of government for that fine speech. Ma'am, we have two POIs from the opposition in the chat box, one by Mr. Ishan and one by Mr. Danish. If you would like to address either one of them.
I'm looking at the one from Ishan. Is that the one which says, would the government legislate against every natural monopoly at the cost of waste of resources?
Madam, I'm sorry to interrupt. Madam Speaker, are we allowed to withdraw one POI of these from these?
Yeah, sure, sir.
We'd like to withdraw.
And also,
Ishan's
if you
POI.
could, yeah, if you could help me.
We'd like to withdraw Ishan's POI, and we'd like to go ahead with Danish's POI on this. If you want any
so
clarification on the POI, yep, please. Thank you.
Danish's POIs, we ask the open challenge again. Let us know of any anti-competitive antitrust conduct which is not covered by the present framework in the statute under section 3 and 4. Is that it?
Yep. Is there any clarification required? I'm more than happy.
No, I'm asking if this is the one that I'm supposed to answer.
That's all.
Okay.
Thank you.
So first of all, I must say it's a very smartly worded question because you've conveniently removed the merger aspect to this, where you clearly need legislation reform. But it's okay. I'll answer this.
Sorry, my apologies to interrupt.
I'm still talking. Can I just finish?
Yeah. No.
So when I'm looking at this question, it talks about antitrust, anti-competitive conduct, which is not covered by section 3 or 4. If you're trying to say that the legislation already covers the antitrust conduct that we can foresee coming from digital markets, then the question to all the audience would be, then why hasn't the CCI done so? Clearly, the CCI needs some more guidance in terms of legislation to direct them in the right way. CCI as a regulator, like my other speakers mentioned, does not even have a technical expert on its role, so they don't know what these problems are. So even if you say that the broad legislation exists, that's clearly not enough. You need to legislate specifically. You need to answer specific questions for markets. And I understand you can't do this for every market, but obviously you can't do this for a pharma market and sector specific, etc. But obviously you would see the difference between these markets, right? Digital markets are creating disruptions all over the world. This is not new. In fact, EC, FTC, they have to go back and review their decisions that they took 5 years ago, because that's how dynamic this market is. So as a legislator, I would assume my job is that I foresee all the problems and give specific guidance to my regulator to show them that, listen, this is where you're going wrong. This is when I give you these broad powers, please use them in this manner and provide some clarifications at the very least. That's the precise reason why we narrowed this definition.
I thank the member of government for that speech. I now invite the member of opposition to continue the case from side opposition. Here.
Hi, good evening, all the members. So firstly, I would like to, hello, am I audible?
Yes, sir, you're audible.
Okay. So firstly, I would like to clear some haze around the issue of acquisition. So there has been a lot of question regarding mergers and acquisition. So firstly, my point is that they have been associating killer acquisition with tech industry. So the problem here is that the understanding of killer acquisition is that whenever there is an intent to acquire a smaller entity, startup, with an intent to shut that business down, but it doesn't include the acquisitions which are in fact successful. For example, the case of Instagram has been, I think it has been asked in one of the question also. So when Instagram was acquired, it had around 90 million user base. Now it has around 1 billion, over 1 billion user base. So what are they complaining about? That an entity has become successful under Facebook after acquisition. So I am unable to follow the point put forth by the government here. So whenever an entity is acquired and the innovation of that smaller startup or business is integrated in the larger ecosystem of the bigger entity, then that is not a killer acquisition. That is in fact something beneficial for the market and the consumer as well. So and moreover, Instagram and WhatsApp have been pointed out by the government. So my point is that the fact that WhatsApp has been acquired by the Facebook hasn't stopped the other platforms like Telegram to innovate and sustain in the market. As in, Telegram has more than 400 million user base right now. So my submission is that the government has been trying to evade by throwing random words like data, network effect, and all that, and hasn't exactly provided any data as to why such practices should be stopped, even when they haven't, they haven't done any actual harm in the market. Next point is that a lot of smaller startups work with an incentive to get acquired by the bigger companies. So the advantage here is that their innovation is integrated with the resource of the larger company. So that gives an incentive to smaller entity also to innovate. The motion of the government here has a potential to kill that incentive itself. So I'm not sure who will be benefited by prohibiting such acquisition, so-called killer acquisition, which I believe are not. So that is something that has to be considered. And lastly, see, the acquisition is not end of the road. So merely because an acquisition has not been notified does not give a free hand to the entity to engage in the anti-competitive practices. So, and similarly, if the acquisition has been notified, the merger has been notified, that doesn't mean the entity won't be engaging in the anti-competitive practices. Like we have seen the case of GoMMT, the merger was notified. So moving on to the next point, I'll take a step backward. So firstly, our standing is that section 3 and 4 are completely capable, and there has been a lot of shouting about data, but I'm unable to understand that the government has not brought in to the force the personal data protection bill or any other legislation. So why I'm pointing this out is because of a German Facebook case. So in Germany, Facebook was being investigated about abusing its dominant position. So the abusive conduct was violation of data GDPR. So during the investigation, the competition watchdog of Germany was in a constant touch with the data protection authority of that country. Now, so that shows that the competition watchdog, the commission, can work harmoniously with other regulators also. And this is something that has been pointed out by the recent expert committee report on non-personal data also, where while recommending the establishment of non-personal data protection authority, there was also a recommendation that such authority can work harmoniously with other regulators like commission, the Competition Commission of India, and other regulators to address the related issues. So my point is that if at all anything is required from the government, is development of a parallel framework that might assess the commission, if at all, but instead of targeting the existing framework of competition law, which is perfectly capable of dealing with all the competition law issues, the government should instead focus on building up the Data Protection Authority and bringing in force the Personal Data Protection Act. And uh, also, for rebutting the submissions made by the previous speaker. So recently, the commission noted in the WhatsApp case 26-2 order that they can look into the data issues if there are, as in arguments in the favor, the evidences are in the favor. So there has been an intention shown by the commission itself that they can look into the data issues, and that isn't something that they are debarred from. So with that, I rest my speech. Thank you.
I thank the member of opposition for that fine speech. I now open the floor to side government to ask any questions to the member of opposition.
If I may, please.
Yeah, ma'am, go ahead.
The government would like to ask the opposition whether they would categorize working to increase a company's own advertisement revenues as anti-competitive conduct. Because this House believes that under the current framework of competition law, this is not. This is considered as legitimate business practice. And yet we see Google consistently buying out all small competitors before they even become big, nipping the competition in the bud and consolidating and monopolizing all access to data for themselves. And the proof of this, having an anti-competitive conduct, is in YouTube Premium. Today, after years of YouTube being given freely to all users, and after YouTube having maintained its monopoly for so many years, escaping antitrust review during the M&A stage or at any subsequent stage, it now increases prices and asks users to either watch 3 ads and then one in the middle, or pay a certain amount so that Google can keep earning revenues out of their data.
Firstly, I would like to say that dominance itself is not prohibited. That isn't something wrong. So if, like I said, Facebook acquired Instagram and WhatsApp, so that doesn't mean that it brought any disadvantage to consumer or the market. It was in fact an innovation. It led to innovation. So the example that you're giving is, see, using advertisement for revenue isn't something wrong, as in it is. So the users decide what they are. The YouTube is just a platform, and users have an option to go for premium or go for ads. It isn't imposing anything, as in there isn't any abuse of its dominant position. If there had been any abuse, then we again reiterate that our Competition Act is perfectly capable of addressing such issues, but there isn't any abusive conduct as such. So YouTube is yes, YouTube is just monetizing its services and not giving it out for free. Thank you.
I thank the member of opposition for that fine speech. I now invite the last speaker of the House from side government, the government whip, to conclude the case from side government. Here.
Thank you. If you just give me a moment, I'll start my speech with firstly the rebuttals, as then followed with, enhancing the points that we've already submitted before this August House. So firstly, you can start the timer, please. So broadly, what we want to start by saying is that in all that we've heard of the opposition, we have not heard a single point credibly, put forth by them that says why we should not be worried at this stage. I think the last speaker from the opposition said that the government has not submitted a single piece of evidence or a fact to really counter what our deepest or our greatest fears in this case is. Let me start by saying that the market share of Google in both search as well as in its Android operating platform, pretty much I'm sure a lot of us would be either using Android or Apple, or and in both of them, in Android as well as in search, they have an 87% market share. And we were discussing about YouTube at length, they have about 30% there. Advertisement, which is the key revenue driver for Google, though they are a search engine, they are at the end of the day an advertisement company. They derive 30%. They have a 30% market share. They are larger than pure play advertisement houses. Facebook, it has 72% market share in social media platforms. The second largest is Pinterest, which is at 12%. It's 6 times smaller. You add another 1.5% on account of Instagram. Amazon has about 40% in e-commerce. These are all large guys. And believe me, we are not saying that large is bad, but over a period of time, what we've come to see is that large has not gone hand in hand with innovation. Yes, over a period of time, whether in India or elsewhere, there has been certain consumer benefits brought by the advent of e-commerce, etc. But that is not the question here. The question here is pretty much whether the tools are sufficient. And I believe, and we believe, that the tools are not sufficient, and we are here to find out a way to basically enable the commission as well as other bodies that we would want to empower to find suitable solutions going forward into the future. The point, I think, when I think there was one question that was asked of us initially by the leader of opposition, what tools are we proposing? I think it was also suitably sort of answered by the government, the member of the government, that we are not putting a tool out there to counter any of this. We are proposing a series of specific actions that could help the commission counter any challenges that may come up going forward. Again, while the Competition Act is something that got enacted in 2002 and got notified by 2011, doesn't mean that the act was envisaged in 2000, right? It was envisaged on the back of the Restrictive Trade Practices and Monopolies Act, which was a very old legislation stemming from the 60s. And then you had, it basically took into account all the changes in jurisprudence in the EC and the US and Canada for the better part of last century to come up with this particular regulation. So in that regard, you're still looking at a legislation that has looked how the law had shaped up in the during the course of the 1900s to the millennia, and not really going into the future. So that is a critical distinction that we have to make. That is something that is, that has to be said. In terms of, I think there was one other point that was made by the deputy leader of opposition regarding the fact that, you can tackle, the ambit of the law is wide enough to tackle under Section 3(1). I believe that very premise of argument was made in a dissenting opinion by one of the CCI's member in the stem cell case. It was not a majority opinion. In fact, there was no finding of there was no finding against that particular company with respect to the exclusionary abuse that was proposed. Again, what in gist that we are trying to say is that CCI really needs guidance. There needs to be somebody with technical expertise sort of added to the CCI. If I may be given 20 more seconds, I'll try and sum up two other critical facts. Spotify is a unicorn. It has run in with Apple Music, and Apple has, told that, it will shut it down. It will not give access to App Store. It's not happened. It is a serious dispute that's on. Paytm has been chucked out of Google's Play Store, and that is a unicorn. That's a large app. It has several vendors that are tied to the Paytm ecosystem. But when Google can do something so brazen to large players, or Apple can do something so brazen to such large players, what is it that happens with the smaller guys? Smaller guys are absolutely terrified to talk about either Google or Amazon, because they know if these are vendors who are dependent on any of their ecosystem, they know that at any given point of time, these guys can come down hard and mess with them. So that's really what it is. At the end of the day, what we are looking is to create a ecosystem for the CCI, for not just the CCI, but anything that looks into digital markets, with the ability to tackle such issues going forward. It's not like, we are reacting at this stage. We've had a run-in of about 10 years where we've looked at host of cases. We've analyzed on a case-by-case basis. And we've said that, sometimes we've even taken a very lenient approach to things that possibly might have not been considered so leniently by the European Commission or by the US. We have given that freedom and room for the tech companies to maneuver and grow. But what we are saying is that, seeing how things are stacking up, it is time for us to take a step back and reassess. Though whatever may be said of CLRC and the other proposed changes, those have not seen the light of day. We are here to specifically look at digital markets. This is not specifically concerning the e-commerce market study. The e-commerce market study looked at a very small subset. We are looking at a larger dimension to it. So with that in mind, I think we I think we are very right in saying that there needs to be a critical change to sort of enable the commission as well as other authorities that we propose to skill and give the sort of enabling laws to sort of go after them in the future.
I thank the government whip for that fine speech. I now open the floor to side opposition to ask any questions to the government whip. I believe there are 2 questions in the chat, sir. If you would like to address any one of them.
So I'm just going to read them. Just give me a second. I think I believe somebody was a bit too excited. There was just too many questions floating around. Okay, I think I'll take the last question that has come from Ishan. Thank you, Ishan. So we are not focusing on false negatives. And at this stage, again, when we are saying that, this is again, I believe this is the Parliament of India. And again, at the end of the day, the question of legislating comes really after. Before we introduce a bill, we are again, gauging your, your reactions and your first thoughts before, we do go and introduce a legislation. And as the the representatives of the government, as somebody who's been elected to be and as somebody who's been elected to represent the country, and as the government, we have a fiduciary duty as well as an obligation to look at the worst. And we see what is unfolding everywhere outside India, and we see, and we've taken and we've been actually a lot more lenient. If you see what has happened in, obviously we know what has happened in the US, we've seen what has happened in Britain, we've seen what has happened in the EC, we've also seen what has happened in Singapore. The kind of questioning that is being done to the big tech companies is on another level. All that, what we are trying to say at the end of the day is, this is a moment for us to pause and figure out our next approach. We cannot have a ad hoc. We cannot have a legislation that says, this covers everybody from salt to rockets, right? It does in a certain way, but specific key legislative changes have to be made for certain sectors. In EC as well, there are specific block exemptions as well as specific laws that cover certain sectors. Now they chose to create a certain exemption or a regulation to target, let's say, the auto sector or the steel sector, only because they believed that there was a requirement for specific dispensation. As much as I figure out that I need to create a special dispensation or exemption, I'm also within my powers to see if somebody needs to be governed slightly more in a more stricter fashion. That's all what we are trying to figure out here.
I thank the government whip for that speech. I now invite the last speaker of the House, the opposition whip, to conclude the debate and extend the case from side opposition. Hear, hear.
Am I audible?
Yes, sir, you're audible.
All right. Before I begin, can I request the moderator to please put on the debate motion on the screen for everyone to see, if it's possible?
Sure, sir.
Thank you.
I
Once
believe
you
it's
can,
yes, sir.
once you can, please feel free to start the timer. No. So let's just thank you to the government for their excellent arguments. Thank you, Madam Speaker, for giving me the opportunity to present my views on this. Now let's go through the motion for the debate for a second. It says traditional competition law tools in the current antitrust framework are not adequate to counter the threat. Now, there are two words which you need to focus on here. Now, can you have that back, please? Thank you. Now, we did not set this, the opposition did not set this, this proposition, the government set this proposition, right? Now, current antitrust regime, which means section 3 and section 4 of the act. Let's speak about section 3 and section 4 of the act. Section 3 covers situations where two competitors like Amazon and Flipkart or Google or Yahoo or Bing, etc., collude with each other to increase prices, exclude competitors from the market, indulge in bid rigging. Section 3 clause 4 covers situations where an enterprise like Amazon indulges in vertical agreements with sellers on its platform if those vertical agreements result in AEC, such as refusal to deal, tie-in arrangement. Section 4 covers situation wherein an entity which is a monopolist wherein there is the only entity, not even a monopolist, just a dominant position. It doesn't even need to be a monopoly. If it has a position of strength, it abuses its dominance. There are stringent penalties imposed. The commission is also empowered to divide the enterprise under section 28. There is a personal penalty also on the officers in charge under section 48. There is a provision, if you are not complying, there's even a provision for imprisonment. My question to the government is this: what is the government supposed to argue now? The government is supposed to argue that the current antitrust framework, which is section 3 and 4 of the act, is not adequate to cover the conduct of big tech companies. Now, which is why we consistently keep asking the government, you first let us know what conduct you are trying to cover, which is not already covered. What does the government? Now, to explain to the audience here, if the narrative says if the law is not adequate, we should increase some protection in the law. I am all for that. provided that the law is not adequate. Now, that's why we consistently ask the government, first, please list even a single conduct. Now, imagine a big tech company like the government said that Google acquires every single competitor. All right. Now, assuming it acquires competitors, first thing first, that acquisition is not against the will of the competitor. Now, if I am Google and I want to acquire a small company, I can't just go out of the way and bulldoze them and acquire them, right? It is not, because most of the time these startups are not listed. I cannot do a hostile acquisition. I have to convince them that, listen, I am going to pay you XYZ amount of money. Please take this money and give me your company in the most simplified manner, right? Even only if that enterprise agrees, only then I can acquire. Now, there is no problem till here. Now, assume that Google acquires everything under the sun. Assume that. And Google has 100% market share, for instance. Tomorrow, it starts charging hideous amounts of money. That's what the government fears. Hideous amounts of money for providing its services. There is a safety valve already incorporated under the Act under Section 4, which says no enterprise which has a dominant position shall abuse its dominant position. There is already a safety valve under the Act. That is why we asked the government, you tell us what is it that we are trying to address here. The government says, no, we don't have any foolproof solution. Today is not the right time. So I ask you this, let us come back once you have the solution. I am all for arguing on this. Secondly, now they are saying, the government is saying that there is a problem in acquiring competitors. Let me enlighten the government on something. Imagine I am a small enterprise where I set up a service which is not in the market. I am called an innovator. Now, my innovation is most of the time set up in a manner that if I do good in the market, maybe one of the big companies are going to acquire me, right? That is how that is how most of the enterprises work, right? My question, madam, if I may request a 60-second extension of the timing. Thank you so much, madam. Now, that is how the most of the startups work. Our assertion today is this. Now, the government says the CCI is not equipped because it doesn't have experts. The CCI is not equipped because the DG doesn't have expert officers. Let me invite the government's attention again to Section 17 of the Act. What does the Section 17 say? That the CCI is empowered to engage such experts as it considers necessary. Now I invite your attention back to the proposition. The proposition says the law is not good enough. The Section 17 is already there. You engage as many experts as you want under Section 17. Our point is not to say that there are no concerns on big tech. My point is the law is already efficient enough to cover everything. The government says only guidance is required. We are only providing guidance. By all means, you should have provided guidance 5 years ago, 10 years ago, maybe when the Act came into force. The question here is the antitrust framework equipped? The answer is absolutely yes. That's why we keep answering the government. You tell us. Now, imagine any enterprise acquires another enterprise, or even any enterprise conducts into abuse of conduct. What kind of abuse of conduct? For example, it says that if you want to purchase X service, you have to also purchase my other service with this. That is already covered under Section 4. My point is, what are you trying to address here? When the audience today votes, they should ask themselves, what is the conduct government is trying to address here? And secondly, what is the way forward? Even if the government were to identify a problem, My question is, what is the solution they offer? We keep asking them again and again. They say, no, we don't have a foolproof solution now. Then why are we wasting the public's time today? This is a legislature house. Let's sit here again once you have identified something. Let's sit here again once you have a solution for that. My only point is, I am not in favor of big companies having privacy issues, the big tech affecting the democratic process. I am completely against that. My question to the government is competition law a solution to that problem? The answer is absolutely no. My last point. The Prime Minister used the word, the regulator has tools in its disposal. For instance, the interim order, section 33, but it doesn't use it as much. But that is not the context of the debate today. The Prime Minister is saying section 3 is available to the government, but the CCI doesn't use it. My question is the CCI, so that means the framework is equipped, right? The framework is well equipped. That is why we threw an open challenge to the government to list one antitrust conduct which is not covered under section 3 or 4. I rest my case, Madam Speaker.
I thank you for that fine speech, sir. I would now remind the audience that the chat is now enabled. If you need to address any questions to one of our panelists, you can.
Sorry, can we sort of ask him a POI?
Sure, ma'am. I was just going back to that. The audience can access the chat now, and with that, ma'am, you can go ahead with your POI.
Yeah. Thank you for your speech. I feel like I want to ask you a question, but I feel like first I should answer all the questions you asked our side of the house. Firstly, I think the opposition is quite misplaced. Sometimes they say, let's look at the motion, read it text by text. Then the other times they say, why you're not looking at pharma companies? Why you're not looking at other sectors? Let's talk about data protection when the motion is clear on big tech companies and antitrust laws. Having said that, I think we need to clarify that, when we define this motion upfront, we sort of dealt with the law being there, not being there, or using remedies that may be in the letter but not being applied, right? We also, in fact, we told you both things. We told you that there are aspects of the law which are not covered. For example, not engaging a technical expert as and when required, but having one on board on a more permanent basis, having a more an enforcement section which is there on a more permanent basis, because these companies are growing bigger and bigger. This issue is becoming more and more centric. It's more intrinsically aligned, right? Then we also told you that 5 and 6, two sections that you completely conveniently missed out, right? Which are also part of the current regime, which need to change if we're only restricting to regulatory changes. And we also suggested maybe, having a regulatory change where the burden of proof is shifted on these big tech companies under section 4 violations or 3-4 violations, and let them show us what is the benefit, since it's so hard to figure it out otherwise. Then when we came to the law, we in fact told you that even though there are provisions, they're not being enforced, right? We told you, for example, that the traditional tool or method in which we look at market power really needs to change. We can't really look at markets as upstream and downstream today. We have to look at markets, especially for these companies which are integrated.
Madam, if I could request you to make it concise, I'm so sorry. I think that's what the Madam Speaker told initially. If I could request you to make it concise. Thank you.
The problem is, instead of having a whip speech, you actually went to the basic premise. So unless and until I clarify that premise, my question won't be answered the way I want. But if you want me to get to the point and, I can hope for a proper answer, let me ask you, do you think the current antitrust regime, using its traditional economic tools, is able to understand the degree to which integrated companies are able to operate in terms of assessing market power? These companies have at the very basis the objective of grabbing eyeballs. Do you think that is something through economic guppy analysis and other things, HHI, we can really figure out? Can we really stop mergers, or can we catch agreements that have this as their objective, looking at traditional upstream and downstream markets the way it's done today?
I'm sorry, is this, should I answer now?
Yes, sir, you can go ahead with it.
Thank you. Madam Moderator, if I could, is there a way I can share my screen somewhere here?
Sir, I think you're the co-host as well. Screen sharing would be allowed for you.
Give me 1 second.
Sure.
Now, I made a reference to section 17. I think, and the government said they should have an expert on the commission on a permanent basis.
You're not
Let me,
answering the question. I'm so sorry to interrupt.
let me finish, madam. Now, let me invite the Honorable Prime Minister's attention to section 17, since he asked should there be a permanent expert in the commission. Section 17 clause 3 says, the commission may engage in accordance with the procedure such number of experts and professionals of integrity who have special knowledge of experience in economics, law, business, or such other disciplines related to competitions as deemed necessary to assist the commission. The provision is right there to have permanent experts. My question, again, coming back to it, you have to point out where the framework falls. Section 17.3, I'm reading it out right there. It says commission may engage any experts with such disciplines related to competition. Secondly, the Madam Prime Minister mentioned that I am not sticking. 1 second. Stop sharing. On that, why is the government, why is the opposition sticking to the antitrust? Because I'm not on merger control. We are more than happy to have an argument on merger control. The trouble is that the proposition which the government itself said includes the word antitrust. That is why we are to stick to antitrust today. Either we can, or if that is the case that we can expand, we can argue anything under the sun today. Let's argue murder laws in that case. I am completely on board with the government on a lot of issues. I am completely on board that there has to be training. There has to be training. There has to be training of the officers in the commission and the DG office. I am completely on board on the government that yes, there should be a guidance given to the commission in the form of a guidance note but my question is, does the act not provide for such tools already? The answer is plainly yes. Use those tools. That is my suggestion to the government. Use those tools. Impart as much knowledge as you want to the commission, to the DG office. Give as much guidance as you want to the commission. But under the garb of adding more law, which you think you may, you are likely to break something which ain't broke. The law is completely fixed and solid in nature. It is extremely lucid and dynamic. That's what I really appreciate about this particular act. It's dynamic. It has a section called section 3 clause 1. It has a section called section 3 clause 1. Give me 1 second. Let me read it out to the entire audience. No enterprise, blah, 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 shall enter into an agreement which causes effect or likely to cause appreciable effect on competition in India. It has an omnibus provision. No enterprise shall enter into agreement which causes effect on competition in India. It's right there. That's what we're saying. Use it as much as you want. It is not qualified by anything. Section 3, it's an omnibus and umbrella provision. Look at section 4. No enterprise or group shall abuse its dominant position. The proposition says the framework is not there. I'm reading out the framework to you. It says right there, no enterprise or group shall abuse its dominant position. What is it that it's not there? Where is it lacking? The government has to point it out to us. That's all we are saying. I rest my case. Thank you very much, Madam Speaker.
Thank you, sir, for that response. I believe I'll have to interrupt here. We wanted to start the polls for the audience to get the results. I would request the tech team to please initiate the polling. During that time, there is a question from the audience. Divyansh has directed a question to Ms. Ravina Setia. Ma'am, if would you be kind enough to answer that?
Yeah, let me just read it.
Sure. Members of the audience, I request you to register your opinions while we've just released. Yes, ma'am, you can go forward.
Thank you. I mean, I think this is sort of underlining our point, right? That regulatory change is something which is very slow in this country. That's something that we see takes years and years. CLRC committee report and recommendations have been submitted, but we don't know when this will see light of day. Therefore, our proposition is that the tools that presently do not exist in terms of practice and enforcement really be used to tackle the threat that these companies pose in the meantime, right? You see other countries, they are coming out with the basic, at least sector specific guidelines and market studies. We need to at least start from that front. We need to at least, section 17 exists, but that technical expert has not been engaged. You need to start doing these things and taking these steps to be able to at least start looking at what's happening, right? You have issues today that deal with self-preferencing, for example, where Amazon will prefer its own products that it makes over other sellers, even though it is in fact competing with those entities in another market, just because of the amount of data it has access to. This is something that the CCI, along with maybe other regulators, can actually take into account if it starts making that, it starts looking at it at least from a more sector specific lens, rather than probably looking at it from as upstream, downstream market specific lens and saying, oh, there are 4 companies active here and 10 companies active there, instead of seeing how much one particular company is really integrated on the front end and the back end.
I thank you for that response, ma'am. I hope the question is adequately answered. I request the audience to kindly vote quickly. We shall be closing the polls by 8:08. So if you haven't voted yet, I request you to vote so that we can arrive at a decision for the debate. In the meantime, I would thank all the participants, all the debaters who have made this possible for our maiden edition to be this successful. I think the audience has gained significantly due to your brilliant, insightful speeches, and I cannot be more grateful on behalf of the DDC for you having consented and having that faith in us to come to the event. To add the last bit of fun to the event, I request everybody, all the debaters and not the attendees, to please switch on their cameras so that we can have a group photograph for a fond memory of the enthralling round that we just had. Could the remaining debaters please turn on their cameras? Thank you. I'll just confirm with the tech team. They're on standby and I'll do a countdown for the picture. We'll take the picture in 5, 4, 3, 2, 1. Thank you everyone for the picture. I believe the polling results are also coming in any moment now.
Yeah, just one more minute and then we'll close the polls.
Sure, Abhinav. Last call to the audience. We're closing the polls in a moment. If you haven't voted, I request you to kindly do so. And the polling is closing in 3, 2, 1. Dear debaters, we requested the audience to register their opinions even before the debate so that we could gauge how much their opinion has changed after listening to your insightful speeches. Right now, I have the polling answers to the first question. Before the debate, 18% of the people were not sure about the motion, 14% of the people opposed the motion, and a whopping 71% of the people were in support of the motion. After the debate has transpired, this has significantly shifted. 0% of the people are not sure, which means that this debate has significantly contributed in the knowledge that they have about the motion now. And I congratulate all of you for having helped us in attaining that. 41% of the people now support the motion, and 59% of the people are now opposing the motion. So, by the mandate of the public, by the mandate of the average voters here, I think the opposition has had an upper hand. However, since this was just a constructive exercise to gain the audience's response, I congratulate both of the teams for putting up a brilliant show and being such sports in joining us here for the round today. I am also apologetic for the delays that we faced during the round, and I will be mindful of that in the future. But again, thank you for joining us today. Thank you for sparing your time, and thank you for gracing RML with your presence.
Thanks.
Thank you. Thank you for your, thank you.